10077 Commonwealth versus Pimental.
Good morning, Mr. Maidman.
Good morning, and if it pleases the court. My name is Stephen Maidman, and I represent Eric Pimental. I'd like to address this morning in my presentation two issues in the case that I believe are critical to this court. The first one involves the denial of the lesser included offense instruction that was requested by the defendant, and the second issue is the preclusion of the defendant from admitting testimony relating to a third percipient witness's observation of Mr. Silva attacking a third party.
With respect to the lesser included, I know it's assault and battery with a dangerous weapon, but was there an instruction given for involuntary manslaughter?
Yes, there was. But in this case, I think the record fairly suggests that the court was unaware of the controlling precedent in Massachusetts on lesser included, on assault and battery as a lesser included offense of murder.
But assault and battery may be, but assault and battery with a dangerous weapon, you could have a murder committed by choking someone.
Sure.
Right. So you don't have a dangerous weapon.
Right.
And you can have A and BDW and no murder, no killing occurs. So each one has an element that the other doesn't.
Right, but that's the same element of the Blockberger test.
Excuse me?
That's the Blockberger test, the Supreme Court
Right, or the
test.
Morey test.
Right, or the Morey test, right, which Blockberger was based on. But that, I would suggest to the court, is not the relevant test in Massachusetts because there's a statute, the statute 278-12, which is quoted in my brief, and that in fact, when Commonwealth versus Myers was decided in 1969, the court referred to that statute. That statute says that the statute goes back to 1784. Very old law in Massachusetts. It's been around for years, and there's not that many cases on it yet either. But bottom line, what it says is that if in the prescribed form indictment, which was used in this case, if it says that, essentially I'm paraphrasing and probably giving the modern syntax, if it says that the lesser included offense is in the prescribed form, then it is the lesser included offense. And that statute's still on the books. So as far as using the same elements test, which would be applicable in determining for double jeopardy purposes, and by the way, the Commonwealth brief is very specific about that. It says for double jeopardy purposes. But this was not, we're not talking about double jeopardy purposes here. We're talking about whether an instruction for a lesser included offense should have been given. And
But it's not lesser included if it has an element that it has an element that the main offense doesn't have. It has the element of dangerous weapon, which isn't included. So how is it a lesser included?
I would suggest that's not the test.
In this case.
In this case. That's the test for double jeopardy purposes. It is not the test for whether a lesser included offense instruction should be given.
But how will it help you? Because the jury found him guilty of first degree.
Well, they were not given the third option. They were not given the third option.
They didn't find him guilty of second degree. They didn't find him guilty of involuntary.
Yeah.
But they could have. It lowered the Commonwealth's burden of proof. They were not. It's the same. It's the same theory. Why? At least for federal constitutional purposes, why a jury is required, when appropriate, to instruct on a lesser included offense in a death penalty case. They could have convicted. We don't. First of all, we don't know that we do not know. They were not given the option. They had the choice of either essentially convicting him or finding him not guilty of murder.
Well, they had second degree and involuntary.
Well, they could do those things.
They
Sure,
found intent to kill.
If that's certainly inherent in murder with extreme atrocity or
and
cruelty.
they're instructed to come back with the highest degree of murder that they find.
Well, that's another issue I've raised in the case, which we'll address separately. But bottom line is that they were not given this option, and the evidence was such, viewed in the light most favorable to the defendant, not to the Commonwealth. The evidence was such that this defendant was entitled to it. It was requested, even in Massachusetts law. It was requested, and viewing the evidence in the light most favorable. I mean, the defendant's entire presentation essentially was, I was with this guy. We walked down a path from the Walmart, and we ran into this guy. And the guy had some words with me, and depending on which of the 7 versions you want to buy of his story, slugged the guy and then kicked the guy. And then the other guy, Mr. Silva, took over and essentially killed him. So if the jury were to believe that, Okay? It doesn't, matter of fact, it doesn't have to even be worthy of belief. The case law in Massachusetts is clear. It doesn't have to be worthy of belief. The issue is, was it in play? And it was in play in this case. And he was not instructed on it. Jury was not instructed on it. So I think it's a fairly strong case that this is reversible error. Let me, unless there are further questions, I'll move on to my
The
second.
dangerous weapon is a shad foot?
Yes. Yes. Wearing sneakers. Big sneakers. Guy had huge feet.
16, size
He had.
16.
I went and looked at. I went and actually saw these things. They were
Are
huge.
they in evidence?
Yes.
We will see them.
Okay. You can't. You won't. You will see them. Unless there are other further questions on this. Let me turn to the second issue, which I think is. It's more subtle, but on the other hand, it's important because I think it affects the current state of law in Massachusetts, and that is whether testimony from Mr. Surdam should have been admitted to the extent that he saw Mr. Silva attack within a couple months of the incident in this case another person with a knife.
But would that be admissible to? I understand the evidence. Is it that it would support his testimony that, or his statement to one of those people that actually he and Mr. Silva had a fight because he was trying to get Mr. Silva away from the victim?
It would support that, but it would also support the fact that this guy, in the same pattern of operation, or whatever the health fant.
It's a whole.
And also, it's not, is it analogous? Because here, in this case, the defendant did participate in the beating by his own admission, and he didn't participate in the prior beating act.
Mm-hmm.
So it's
But
not,
we don't-
it's not a prior similar act.
Well, I would suggest, with all due respect, I would suggest it is. And the reason I say that is, yes, there's no question that he participated in, at least initially, given the...
And that he didn't in the one in his apartment.
Well, that's right. But the bottom line is this guy went and attacked the other person. And this was powerful
the other
evidence.
guy's a bad guy. I mean, I think the jury was clear. There was plenty of evidence before the jury that Silva was a bad guy.
Yeah, well, I'm sure that I think you're right. But this evidence was powerful evidence. The Commonwealth filed a motion to eliminate prior to trial to keep it out because they knew it was powerful evidence. And you have to ask yourself, from a policy standpoint, why isn't this evidence admissible?
So
I mean, it didn't.
Because it wasn't
what's
the
it
same.
for? What's it telling you? What's
It tends to
relevant
show that this defendant, that the man with this defendant attacked the other guy viciously, and the defendant had to pull him off. It shows this guy.
So it's supporting his statement.
Yeah, it's supporting his statement, but more than that, I mean, if you were to believe one of the versions of the defendant's story, either to the police or to the other witnesses, yeah, his story is the guy swung at me, I punched him a number of times. I don't think it's in the record, or if it is, it's probably a mishmash. And then I kicked him, and then this guy started beating the living daylights out of him. That is not inconsistent with Mr. Surdam's proposed testimony. And you have to. I think the court needs to consider that. Why shouldn't the jury have been given this testimony? It didn't prejudice the Commonwealth. It didn't prejudice them in the least. The jury could have sorted this out, and there's case law in Massachusetts that says that all doubt should be resolved in favor of the defendant, and that didn't happen here, and I would suggest to the court that it should have been admitted, and I quoted Wigmore on this, and because he's directly on, it's in my brief, he's directly on point, and you know, why, if the defendant is not, if the Commonwealth is not being unduly prejudiced, let's put the word unduly in front of it.
This is Wigmore on third-party culprit evidence.
That's right.
But I mean, it's a very different. It's the normal third-party culprit is somebody else did this, and who I wasn't there.
Right.
Somebody else.
It's identification evidence.
Yeah.
Yeah, that's correct. That's what the cases talk about. But why? But it's not limited exclusively to this. There's no reason to limit it exclusively to this, especially when you're trying to show relative culpabilities.
But what is the inference? I mean, if the Commonwealth had evidence that Silva and Mr. Pimental had earlier beaten up somebody, would that come in under the same principle, or is this a principle only for defendants? And if so, what is the principle?
Well, certainly if Mr. Silva and Mr. Pimental had beaten up someone previously, assuming it wasn't unduly prejudicial, which it probably is, that the Commonwealth would have been doing everything possible to get that evidence in.
But how would it come in, as pattern and practice?
Sure. Why not?
One
You think
instance?
so? I mean,
If
you would be jumping up and down if that came in. You would be jumping up and down.
Oh,
if that-
absolutely, I'd be jumping up and down, certainly.
And-
But
and
as
maybe
being
rightly
unduly
so.
prejudiced.
Yeah, well,
right,
and rightly so, because
Right.
what does it show about what they did on this occasion?
But why shouldn't the benefit? But the Commonwealth. Typically, there you're dealing with prejudice to defendants' constitutional rights to a fair trial. What did the Commonwealth is not being prejudiced by this. The jury could have sorted it out.
But if the
I'm having a little bit of trouble with the benefit to the defendant, because in the prior incident, the person who intervened apparently intervened successfully. Pulled him off, pulled Silva off of
Right.
the victim.
It was the defendant who intervened in that previous incident.
And successfully pulled him
Yes.
off. Didn't do it here.
Well, he testified that he did.
But he didn't. Because Silva kept on kicking.
Yes.
So arguably, it is not the same kind of a situation,
Well, but it's close.
and it contradicts the defendant's own testimony.
I don't know if it contradicts, but I think it supports his testimony. I mean, the defendant's theory of the case was.
I'm sorry, not his testimony, his statement to the police. Yeah.
He does admit he kicked him. But again, the defendant's theory in this case, the defendant's presentation essentially was, well, yes, I got in a fight with him, but I didn't mean to kill him, and this other guy got completely out of control and beat the living daylights out of him. I think that's a fair reading of the evidence in the case. And here is some evidence which supported that theory. And it was precluded, and the jury was entitled to hear that. And there's no reason. Matter of fact, I guess there was no downside to no legitimate downside to the Commonwealth. And why shouldn't it have been admitted? There is case law on this in the federal.
On that theory, you could put in anything and everything if you could just say, well, it's not prejudicial to the Commonwealth. I mean, before you get there, it's got to be material and relevant to something.
Well, I would suggest to you in the test in the case, in the Massachusetts case, is it normal standards of relevancy apply? It was relevant. If the jury had heard this, what would the jury have said? I mean, maybe they would have said, well, that's nice, but meanwhile he still beat the living daylights out of the guy with this other guy. Okay, but again, the jury had the right. They should have had the right to hear this evidence, and maybe they would have said, well, it certainly sounds like the defendant's presentation. This guy's out of control. Here he is, 2 months earlier, pulling him off another person, and again. This defendant, as all defendants, is trying to raise reasonable doubt. I would suggest to the court it raises reasonable doubt, and that's why the Commonwealth moved prior to trial to keep it out. I mean, that's the strongest. I would suggest that's some indication of what the Commonwealth thought of this evidence. And unless the court has further questions about anything else in my brief and my reply brief. I'd rest on my brief.
Let me just ask you one question about the prosecutor's closing argument.
Yes, let me just turn to those and make sure, because there are 4 of them, and I want to make sure I appropriately address them as best I can.
I want to make sure I understand that part of your brief where you say that there is no evidence from which the prosecutor could have argued that they set out to rob the victim.
Yeah, there isn't.
Yeah.
I mean, this was a chance encounter on a wooded trail in the onset section of Wareham, essentially coming from a Walmart to where the defendant lived, and this just happened.
Now, the Commonwealth takes the position that, well, the jury didn't have to believe the defendant's version in the statement he gave to the police, but was there? And they don't have to.
Right.
But from where does the evidence come that they believe the opposite? That's your argument.
I don't know, but it's pure speculation.
Well,
I don't know.
there was evidence through the defendant and the girlfriend, I guess, that A, stuff was taken from him, and B, that the defendant himself got some of the stuff.
That's correct. Which is the whole issue of how the guy was convicted in the first place of armed robbery. There is no evidence in the record that the defendant took something at the crime scene, participated, went over and said, "Let's go get his money." There's nothing even close to that. He was hooked on the armed robbery, essentially, and it was argued by the Commonwealth because they found his cigarette lighter and some money and stuff like that on him. I don't know how anybody could argue that this guy was set up to be robbed, because the evidence just doesn't support that.
If he's beaten up and then when he's laying dead or near dead, they take things from him, why is that not armed robbery?
Well, that's interesting. Whether it really is, from a conceptual standpoint, armed robbery. If the criminal transaction's over and then someone takes something, that probably is an armed robbery. But bottom line is, my defendant didn't take anything. He may be guilty of receiving stolen goods.
But he's in a joint venture with the person who did take it.
But there has to be some evidence that
he was standing there when it was taken.
But I would suggest that it requires some evidence. At least that there can be inferred that he shared the mental state to rob the guy. And there's just I don't
well,
think
standing there helping to kick him to death, and while the other person is taking the money out of his pocket.
No, the evidence not that clear.
Some evidence.
Not that.
Ending up with some.
I don't think. I'm not sure the evidence came in that way. I mean, obviously that could be argued, but I'm not sure that. The way I read the transcript was that maybe I'm reading it in the light most favorable to the defendant. I'm certainly been known to be guilty of that. But is that this guy goes up to the defendant, has some words of some nature, swings at him. The defendant starts punching him, and then kicking him. And one of the issues where he was kicking him too. That's another interesting question, which goes to, was this the cause of the death? Because there was a lot of medical testimony how the guy was stomped on his chest, lying on the ground. That how you break all the ribs and basically kill someone. Whereas if you kick somebody on the side, unless you're up against a wall or something, it's not going to have the same deleterious effect. But I guess just to answer your question, I don't know how, based on the evidence that was in the record, someone got to say, "Oh yeah, this was a robbery." I mean, yes, there's no question he was robbed, but whether this defendant had the mental state to commit any crime with this guy is certainly at issue in the case.
But the jury didn't find him guilty of felony murder. They found him guilty of
armed robbery.
Atrocity and armed robbery.
Armed robbery. Apparently, they didn't. They somehow. I'm not sure how that happened. That may be a little bit inconsistent.
Thank you, Mr. Mason.
Okay, thank you very much.
Ms. Lee?
Good morning.
Good morning. I think it was Commonwealth versus Moran. Two guys beat up a victim, stuffed him into his truck, and as an afterthought, one of the co-defendants took his wallet. And in that case, we said that could not be the basis for felony murder or, I believe, armed robbery. I may be wrong about the armed robbery.
Because he was already dead? Is that?
I'm sorry?
Because the victim was already dead during the robbery?
No, because the removal of the property was the jury could have concluded that the removal of the property was merely an afterthought and was not the motivation for the assault in the first place.
So it wouldn't be a felony murder, but it would be an armed robbery still?
It might not be an armed robbery either. In this case, what was the evidence on which the prosecutor argued to the jury that they attacked the victim with a motivation to rob?
Sure. Basically, you have much of our evidence comes from the defendant's various statements to people. So he didn't testify, but it comes from the various statements to people. And I also should probably preface my comments with the defendant was not convicted of felony murder here.
No, no,
Just
no, we know
extreme
that.
atrocity and
It's
cruelty.
in.
Okay.
But it was given to the jury.
It was, oh yes, it was instructed. So basically, the defendant says he kicked the victim. The defendant says Silva kicked the victim. And he says that he and Silva kicked the victim at the same time. That comes through Sardam's testimony primarily. The victim dies from a wound that is consistent with the force of a leg muscle. It's his fatal wound is a broken sternum that one of the broken pieces punctures his heart. And so that is not force that you can do with a punch. That is a leg forcible wound, a leg
He's
muscle
on the
wound.
ground and somebody
So
stomps
he
on him.
dies from a kicking wound. And then after the crime, it's approximately 4 to 5 in the afternoon in the park. Mrs. Brown is there with her son, and she sees the two defendants, and they have a backpack. They are not fighting. They are not arguing. And there is blood on the defendant, Mr. Pimental.
They killed a guy. They killed him.
Sure. And-
What's the evidence that
and
they
then-
did it? That
And then later
robbery
on,
was,
Pimental says he's got $70 and a lighter, and he tells his girlfriend, because he's unemployed, she's like, where did you get the money? He says, that's the money from the guy we beat. And the lighter, he now has 2 lighters. He gives the second lighter to his girlfriend. That's the dead guy's. Well, he wasn't dead at the time. He didn't know the guy was dead at the time. He says he found out the next day the guy died. He says, that's the guy we beat. That's his lighter. So the reasonable inference here, and I cite to Commonwealth versus Newman, which is cited in my brief, the reasonable inference here is that it's one of the possible reasonable inferences, but one of is that they
But
beat
it's
this man
reasonable.
and
But
took his
it's-
stuff,
but
and
it's
that's a
reasonable.
robbery.
It's not
That's
the
an armed
only
robbery.
influence, but it's a
Excuse
reasonable
me, a
influence.
reasonable
Right.
inference is what?
The reasonable inference is that they beat this guy up and they took his stuff.
okay.
And inferences, unlike elements at trial, don't have to be proven beyond a reasonable doubt. They need only be reasonable and possible. But I would further, and I don't mean to repeat Justice Gantz, but I would further point to the prosecutor's argument when she said, they beat this guy so they could rob him. That's the inference she drew, and she's permitted to draw all reasonable inferences from the evidence, all the evidence at trial. And she did that. She's not bound by the defendant's theory that he tried to stop the robbery or said you shouldn't do that or any of that kind of thing. Kane and Sousa says she's not bound by the defendant's theory of the case. But she drew that inference and then immediately followed it with, this is why it's a felony murder, blah, 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 felony murder, blah, blah, blah. And the jury did not convict him of felony murder. I stand by the prosecutor's argument. I think this is a reasonable inference, certainly based on Newman and Pina that says inferences need only be reasonable and possible. I stand by her argument. If this court finds that that statement cannot be drawn from that evidence, there was no objection. There's no substantial likelihood of a miscarriage of justice in these
They
circumstances
rejected the theory.
because they rejected the theory that she was arguing when she said the intent for the beating was a robbery. They, rejected might be too strong. They only found an extreme atrocity and cruelty, so the defendant did not suffer any repercussions from them accepting that theory she was arguing because they did not come back with that verdict.
I have a question on third-party culprit.
Yes.
You, in defining it in your brief, say that the third, along with the other prerequisites for third-party culprit, more probative and prejudicial, et cetera, and that the evidence tends to exculpate the defendant. From what case do you get the requirement that it must tend to exculpate the defendant?
I'm relying on Conkey, Holliday, and Clark, but what those cases say, and they say, is that the evidence must tend to cast doubt on the defendant's guilt. And so when I say tend to exonerate or tend to exculpate the defendant, that's the standard. And I apologize if that language was confusing, but they sound the same to me. But the exact language from Holliday, Clark, and Conkey is tend to cast doubt on it. And the defendant then points to, bless you, the defendant then points to the U.S. Supreme Court case saying, Ms. Lee's way off the mark. That's not what the U.S. Supreme Court says, and goes to the Holmes versus South Carolina case. And that same exact language, tends to cast doubt on the defendant's guilt, is approved in Holmes versus South Carolina. Holmes versus South Carolina is a case where they wouldn't let in any third-party culprit evidence because the Commonwealth's evidence is so strong, it's got DNA, blah, blah. That's not a situation we have here. Not only was the third-party culprit evidence fully expanded, Silva did it. Silva kicked him to death. I tried to pull him off. I couldn't stop him, even though I outweigh him by 70 pounds and 6 inches. I couldn't stop him. Silva killed the guy. I told him you shouldn't take his stuff. I didn't take any of the stuff. Of course, he's found with the stuff later. So all of that evidence, not only was it presented to the jury, but it's presented in the Commonwealth's case in chief. The defendant did not call any witnesses. The only thing that's kept out is this prior bad act by Mr. Silva. And I would, again, point to the Holiday case. The Holiday case was, should the third-party culprit's racial animus generally come in to show murder, in this case where it is an interracial murder. And in that case, it wasn't sufficiently connected, and it was perfectly all right to keep that out, particularly where in Holiday the other parties, the third parties' opportunity and other motives were fully explored as they were at this case. So I think Holiday is right on point in this case.
What is the evidence that he was a principal as opposed to a joint venture?
Sure. The defendant, Eric Pimental, told, it primarily comes through Surdam, so I'm going to start with Surdam's testimony. Surdam's his best friend, or one of his best friends. And he said, I kicked him. I kicked him twice. I kicked him at the same time as Silva. I kicked him while he was on the ground. I kicked him 6 times. He says a couple of times and then also says 6 times. Surdam tries to dispute that, but admits that he told the police that and adopts that statement at trial, and then in cross-examination tries to weaken it a little. And the victim dies, as I've explained before, from this severe kicking wound that occurred while the victim was on the ground.
So basically you don't know, it could be either of them, is your point?
And that doesn't matter. It doesn't matter in these circumstances because the case is escaping me right now.
Williams.
Williams and Phillips, I believe, citing Williams, has a very good quotation on it regarding the fact that it doesn't, okay, here it is. When evidence establishes 2 people are culpable for a crime, but the evidence fails to establish who was the principal and who was the joint venturer, the jury are warranted in finding both were either the principal or the joint venturer in Phillips and Williams. I would suggest in this case, probably Silva and Pimental don't even know who administered that kicking wound. This was extremely violent death that Mr. Loftus suffered. I mean, we're talking about, the broken jaw, which is the punch probably from the defendant. Pimental socked him right in the face first off. That was after Mr. Loftus had swung at him. But he also has, he's got broken ribs. The broken ribs are puncturing his lungs. His face is unrecognizable. The original person who, the man who was walking his dogs who found the body, he described it from a layman's perspective that it looked like there was a bone sticking up out of his back. That was not, described clearly by the medical examiner. But, this guy, this was not like 2 punches and walk away. This guy's, he was taken, and pummeled. Miserable death. They probably don't know in the fervor of their attack on this man who's the one who did it, or maybe they did it together, who knows, and the jury doesn't have to know under Phillips, Williams, Johnson, Perry. And in terms of his mental state, the mental state that he has to have, that we have to prove in order to support this conviction is malice, any one of the 3 prongs, because it's extreme atrocity or cruelty. And even the defendant's own statements lend themselves to that. I know that it's intent to do grievous bodily harm, but the defendant says, yeah, he was beaten pretty bad. We hurt him worse than we meant to. So even his own self-serving statements show that they meant to hurt him, but they didn't mean to hurt him as bad as they meant to, i.e. kill him. That's what they did to him. So I would suggest that shows it right there, intent to do grievous bodily harm. But you don't even need to go there. You have 3rd prong malice. Clearly, the severity of this beating, and the cases support that, the severity of this beating shows sufficient malice. And I cite Chim, it's C-H-H-I-M, and for extreme atrocity and cruelty, there's the Anderson case. It's Tanzarius Anderson. I know there's a lot of Anderson cases.
Now, was he left in any area where anybody would likely find him right away, or? The
Commonwealth's evidence shows that it looked like he had been moved. There's a pool of blood near the path. The body is about 30 feet away from the path. The police officers testified that what they saw looked like the guy had been dragged because he's face down. There's leaves bunched at his underarms. His shirt's rolled up. their shirt is rolled up, and so all the blood is pouring into that area, wicking into the T-shirt that's rolled up around him. His pant leg, well, they're shorts because it's June. His shorts are rolled up a little bit. His legs are spread eagle. It's not the typical way you would fall. Although the defendant's testimony is they were walking away, he was still getting up and walking around. The medical examiner said, unfortunately for Mr. Loftus, that this kind of injury where the heart is punctured, Mr. Loftus could have actually walked around for a little bit because he would have been bleeding out into his body from his heart. And so it would take 1 to 2 minutes of that suffering and dying. And the medical examiner said it's possible he could have even been getting up or trying to get up or walking or even walking around a little bit, depending on, how quickly he was dying. So it fully supports extreme atrocity and cruelty on principle and also by joint venture under Phillips and Williams. The evidence was overwhelming on extreme atrocity and cruelty in terms of the numerous injuries to this man. I would like to address the assault and battery with a dangerous weapon instruction if there aren't other questions on the other
You mean
points.
the failure to instruct?
I'm sorry?
The failure to instruct?
Yes, the failure to instruct. The instruction was requested. The defendant objected when it wasn't given, so this is a preserved issue, and the standard is whether there is prejudicial error. And I would suggest to the court that it's not an error. The Commonwealth maintains that assault and battery with a dangerous weapon is not a lesser included under double jeopardy analysis, and we cite the Edge case, which is recent. Also, Blockberger is cited within that. It's the Morey test. And the defendant says that the double jeopardy analysis doesn't apply, and in his reply brief he refers to Chapter 278, Section 12. In that statute, as I read it, says that you're convicted of everything in the complaint that you're not acquitted of. So you are convicted of the residue, and so the defendant's argument, as I read it, I don't mean to speak for him, is that any crime that's contained within the complaint that you're not that you're acquitted of, that you're not acquitted of, that's the lesser included you get. So I went and looked at our indictment, and we don't talk about any dangerous weapons. It says assault and beat Mr. Loftus, and by such assault and beating did kill and murder Mr. Loftus. So what the defendant would be requesting is that he be permitted to be convicted of a crime that is not charged in the indictment.
But you proceeded on a theory of felony murder, armed robbery,
Yes.
which in the arm, the weapon in that case, I take it, was the shod foot.
Yes.
So if your theory of the case, or at least your theory of one theory of the case, the felony murder, included a dangerous weapon, why isn't it a good argument?
First, it's going to point you to the complaint is page 6 of the defendant's record appendix. And to answer your question, my understanding of armed robbery is that you are armed while you do the robbery. I don't know that you have to show that it has to be that you don't have to shoot somebody, or you
You don't have to actually have contact.
You don't have to
You don't have to have a battery as part of it.
It doesn't have
actually have to have a weapon. If you say something that I have a gun,
right, and
you're still
and then you
convicted of
run
armed
out
robbery,
and
even
they don't
though
catch you
you
right
don't have
away.
the gun.
Yes, and there's an inference that you did have a gun. We take you at your word.
Right.
But you do have to have the inference that there was a weapon. But you don't actually have to use or show the weapon. Assault and battery with a dangerous weapon, you have to have a beating with a weapon. And so that doesn't help the defendant. I have grave constitutional concerns that if you require the court to instruct on assault and battery with a dangerous weapon when that has not been alleged in the indictment, that I'm going to be standing up here going, but don't reduce it to an assault and battery because that's the only lesser included for murder, and that's the only thing that was alleged. I'm not asking, by the way, as the defendant suggested in his reply brief, that you should overrule Myers. Myers is correct. Assault and battery, simple assault and battery, is a lesser included offense of murder. I agree with that. It's correct.
but you think Charles should be
Charles needs to be overruled because that case does not go into any analysis whether this underlying charge, whether that is a lesser included. It just says assault and battery with a dangerous weapon, it has a lesser included of assault and battery, and so does murder. So it logically follows that they're lesser included, and it doesn't logically follow just because, I have a half-brother, and this other woman has the same half-brother, it doesn't mean that we're sisters, because there could be other parents in there. That's, I'm sorry for the common analogy.
Excuse me, Ms. Lee. What happened to the indictment on armed robbery? He
This is a conviction.
He was convicted, yeah.
And I don't think that, I know this isn't part of the record, it's not part of the claims that the defendant is making, but for the purposes of 33E, I don't think those are inconsistent at all. I mean, first of all, inconsistent verdicts are permissible, but aside from that, they're not inconsistent. It shows that the jury had some concerns about whether the intent was a robbery or whether this was this opportunistic fight. They got mad at each other, the fight gets out of hand, they really beat this guy.
How could it be a fight, given the size of the two people? And
I know.
I mean, when I saw the word fight in the brief, even in your brief, it doesn't seem to me this was a fight.
Well, that's how the defendant described it, and we don't have any other witnesses to it, but he called it a fight. I got in a fight, but the defendant is almost twice the size of
And there were two of them.
victim, and he has Mr. Silva, who's also much bigger than the victim. The victim is very drunk. And he's out in the woods alone.
Were either of these two assailants, were they drunk?
There's some evidence that they were drunk, and there's some evidence that they were sober, and the jury was properly instructed on intoxication regarding that. But he lived with his cousin, Melissa Johnson, and she testified, and she said they were having Southern Comfort. He's 18 years old, and I say that in terms of sophistication with drinking. So he's 18 years old. He's sitting around during the day drinking at her house, Southern Comfort, and with someone else. It's hard to tell if the someone else is his friend Rob Silva or the unindicted at the time co-venturer Robert Surdam or Robert Silva. Robert Silva's the co-venturer, Robert Surdam's the friend, because she said his friend Rob or something. So there's some evidence that he was drinking in advance. Mrs. Brown saw them what appears to be minutes or shortly afterwards, and they were fine talking to her. You must know Silva's grandmother. She's big in town. Oh, I got my leg cut on brambles. They're not acting drunk. They're not acting inappropriately. They have a fine conversation on an afternoon that didn't bother her at all. So I would suggest there's some evidence of alcohol intoxication. There's some evidence of sobriety. I think his girlfriend said that he was drunk when she saw him. So I would just suggest that assault and battery is not a lesser included offense. The judge was correct in not in giving that instruction. I'd ask you to overrule Charles. I would note that this court found in Commonwealth versus Pove Hour, which I'm sorry is not cited in my brief, but it's H-O-U-R. In dicta, this court calls assault and battery with a dangerous weapon a lesser included offense of murder.
What's the site for that? What's the site?
Pove Hour, and the site is 446 Mass 35. It's a 2006 case, and you'll find that at I'm not finding the pinpoint site, but it's in Part 2B on the jury instructions.
Did you give that to Mr. Maidman? I mean, no. I said, did you?
I haven't. I'm sorry.
Okay, well, just send us a letter, would you, and then CC Mr. Maidman on it.
I'll make sure that
And
he
you
gets.
say that in that case we said A and BDW was a lesser included of murder?
You call it that. I think it's dicta, but this is the line. It says there was no error in the judge's refusal to instruct on the jury on the lesser included offense of assault and battery by means of a dangerous weapon shod foot. So they call it you call it a lesser included offense, but because you find that it wasn't required on the facts of that case, and there's no analysis under the same elements test, I suggest that that's dicta, and I'm sorry I didn't find that case when I wrote my brief. But I would ask you to overrule Charles. If there are no other questions, I would ask this court to affirm the defendant's convictions.
Thank you, Ms. Lee.